Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
And thank you for joining us again for the Jury Thinks What. This is a podcast for trial lawyers by trial lawyers. My name is Saul Gruber from Gruber Trial Consulting, where we are assisting lawyers all over the country get ready to try cases, do focus groups, as well as help them with their nursing home cases. This podcast will have trial lawyers just like you and me as guests once a month. And these are lawyers that are in the trenches where we can talk about different issues that we see coming up all the time as lawyers. These are things that could be something as simple as putting pictures into evidence, and something as complicated as outlining and preparing your themes or openings. The real point is we're here to help. We know that there are a lot of lawyers out there that are younger in nature and possibly don't have a mentor. And we want you to think of this podcast as, well, your podcast, and this podcast as your mentor. And that is the purpose of what we do. Again, I want to thank you for joining us, and I'm really looking forward to this week's guests. So we're back, and today we have, I'm pretty excited about having Brian Brown on our show. Brian is not only one of the top lawyers in the state of Maryland, but I also consider Brian a friend and a wine connoisseur, which is kind of important to us at Gruber Trial Consulting. But Brian has tried well over 100 cases. Think about that, 100 cases, which means a lot of the things we're going to talk about today is like second nature to him. And he's recovered more than $175 million for his clients. And most recently, which I think is incredibly impressive and well-deserved, Brian was selected as Trial Lawyer of the Year by the Maryland Association for Justice. And that's, if you're not familiar with those type of things, the state TLAs will do this. And in Maryland, it was deemed that Brian did the most for both society as well as his client, and maybe even change the law in Maryland. And that's something I think as trial lawyers, we all hope to do and not often get to do. So welcome, Brian. How are you today, Brian?
I'm well, thanks. Great to be here with you.
So tell us more about becoming the Trial Lawyer of the Year of 2020. Were you surprised?
I was shocked, to say it mildly, but I have to correct you with one little thing. You said Brian, but it wasn't just Brian.
Right.
I mean, there was an incredible team of people that got us to where we were when we tried this case, and people who worked in this case for years, even before I got involved, who took it, and I got to take it to fruition.
So let's talk about the case. I'd love to hear more about the case. Tell us what it was about.
So the case is called Parlow, with my client, Ashley Parlow, versus Kennedy Krieger Institute. Kennedy Krieger Institute is a world-renowned institution. It's part of Johns Hopkins Hospital, and they specialize, their practice is pediatrics, kids with problems. Now, let's go back. Still to this day, but for decades and decades and decades, lead paint poisoning was a tremendous scourge in Baltimore and older cities like Baltimore where the housing stock is old.
Sure.
And kids were being poisoned and permanently brain damaged because of their exposure to lead, most of the time in the housing where they lived. So Kennedy Krieger, which by the way, and I said this to the jury, is a great institution that's done lots and lots and lots of good, but they lost their way on this case. And what they did is they devised this experiment whereby they would recruit landlords who owned houses in the city with lead paint in them. And they said to the landlords, we will give you money to repair your houses, but at 3 different levels of cost and extent of the repairs. And I'm making these numbers up. I forgot the numbers now.
Right.
But they would say, we'll give landlord group A $3,500 to repair their house, landlord group B $5,000, and landlord group B $7,500. And those aren't the exact numbers. And they specified each group had the exact same repairs done. If you were the lowest level, you got A, B, and C done. You got a little more in the middle level and a little more in the highest level. And then what they would do is they would have the landlords recruit families that had at least one child between age 0 and age 4, and say, we won't rent your house unless you have at least one kid between age 0 and age 4. And they put them into the house, and then they would compare the kids' blood lead levels as against what happened with the different levels of repair.
Wow.
And so basically, they use these kids as guinea pigs. Now, here's what happened.
Almost literally use them as guinea pigs.
As guinea pigs. Now, the trial judge wouldn't let me say the word guinea pigs at trial, but that's another story when we get to the trial. But this case was first brought, the original incarnation is called Grimes versus Kennedy Krieger Institute. And 2 other lawyers, Saul Gruber and Susie Shapiro, they brought that case for Grimes. And it was in that case where the Court of Appeals, which in Maryland is the Supreme Court, it's called the Court of Appeals here.
Okay.
They excoriated Kennedy and basically compared this study rightfully to Tuskegee and Nuremberg and all of it, and said that they owed a duty of care to study participants. And the case went forward. And because it came back, the Saul and Susie lost on summary judgment. They took it all the way up to the Maryland Supreme Court, sent it back. Okay?
So a court actually said they had no duty?
The trial court said they had no duty. That's correct.
Wow.
Okay, so it went up and Susie and Saul got it reversed and set the stage. Our case was different because my client was a sister of the study participant. She was not in the study itself, but she was in the house, and Kennedy knew she was in the house and knew that she was being exposed to the same dangerous leaded conditions as study participants, my client's siblings.
So she's in the zone of danger, I think some courts have called it.
But she was too old. She was over the age of 4, maybe it was 5, I forgot now, but she had aged out. She was aged out of the study, but she was still there being poisoned. And so again, they said no duty. And the circuit court granted the motion and said they don't owe a duty to a non-study participant as opposed to a study participant. And again, we appealed that ruling obviously to the intermediate court, where we were successful. And the Kennedy asked for certiorari, which the Court of Appeals granted. It went up, and in a 4-3 decision, thank goodness, 4-3,
wow,
we won, and the court said there was a duty. And the whole issue in that case was they argued that it will result in an indeterminate class of plaintiffs, and they didn't want to broaden the duty. That was Kennedy's argument. And there are other cases in Maryland for other kinds of issues where the court has refused to impose a duty for that reason. And by a 4-3 decision, the court ruled our way, and we came back and we tried the case, and we were the first case, either under the Grimes scenario when it was a study participant, or in our scenario was a non-study participant where a plaintiff's verdict was obtained. In all the other cases that came before us was defense verdict every single time. So
I was about to say you were like a bellwether case, but maybe not so much because you just happened to win it. Did all the cases settle after your verdict?
Well, that's a great question, and the answer is there were no other cases that I know of after our verdict, because don't forget, even though the statute of limitations is told until the kid turns 18 and then the 3 years starts running. Right. The study was done so long ago that there are no remaining viable plaintiffs left because their statute would be gone.
So I'm assuming the case law that you made, I call it the zone of danger, but it certainly the foreseeability of who could be a plaintiff is being used in all sorts of cases now.
Well, so you're asking really good questions. So the foreseeability is the main thing. So the main point, at least in Maryland, that courts look at in deciding whether or not to impose a duty, the first that they look at, not the only, but the first is foreseeability. So yes, that is a factor. But to your point, is it being used in other cases? People are probably going to try, but the court, if you look at the head notes, even the court's own synopsis of the case, they really narrowly tailored their holding to a medical study where the researcher knows or should know that there's somebody who foreseeably may be injured. I mean, they set out a certain set of bullet points, which very much limited the holding of the case.
Because I would think a case like that could be used for construction issues in a construction case, or now that we're in COVID and you're talking about foreseeability and people in the zone of danger, whether it be a nursing home or somewhere else, I could see that being a real issue.
You could have 5 more shows on that topic, but yeah, I mean,
true.
Obviously the common law develops by growing from previous holdings. So yeah, right. Of course people are going to use this decision to try to impose a duty in another way. But to be fair, the court's holding was limited, and so you would need some very creative lawyering to get it expanded.
How has your Supreme Court changed at all in its makeup since this holding?
Well, yes, and it's amazing you asked that question, because approximately 2 weeks ago, because of the change in the makeup of the court, Maryland is now a Daubert jurisdiction, whereas before, for 40 years, we were Fry Reed.
I'm down in Miami, and about 8 months ago, our Supreme Court went to a Daubert, and they overruled the Supreme Court, maybe that ruled we're not a Daubert state 8 months before then.
Yeah.
And it's just the new makeup made us a Daubert state, which of course threw everybody into a tizzy down here.
Well, interesting. So I had a case a few weeks ago. Was beginning of August, and this case that I told you about was decided August 30th. That we went to Daubert. But the defense had made a motion for a Fry Reed hearing, and the judge agreed to hold a Fry Reed hearing. But with opposing counsel, I said, Judge, you got to postpone this hearing because, and by the way, in Maryland, every case, our terms go from September 1 to August 30th. That's the Court of Appeals term. And the rule is every case argued during a term must be decided during a term, that same term. So the Daubert case called Stevenson versus Rochkind versus Stevenson was argued in February. So we knew we were going to know one way or the other whether we were Daubert or not by August 30th. So I said, Judge, please postpone this hearing so we know what standard we have to decide admissibility. And she did.
It takes us a little off where we were going to go, but I'm curious, have you dealt with a Daubert hearing yet in Maryland?
Literally, it will be impossible, because think about it. We just became Daubert August 30th. You have 15 days to respond to a motion. Right. So literally, now on that note, we did get a Daubert motion yesterday. In one of our cases, and it's due in the response is due in 13 days.
It's interesting because I've participated in Daubert hearings in federal court, and just the whole nature of the judiciary in federal court, as you know, is completely different than any state court. And it will be interesting to see how state court judges deal with the Daubert. I'm trying to think of the right word, the draconian results of certain Daubert hearings.
Yes, and it was argued, and by the way, the lawyers on the losing side of that case, who I know them both, again, Susie Shapiro and Scott Nevin, they filed yesterday a motion for reconsideration of the court's ruling. Now, the chance of that being granted is, not too great. No. But one of the things the court did, which I hope they do change, is that they remanded the trial. And by the way, this case has already been tried 4 times. 4 times. So remanded for a 5th trial.
Oh my God.
But they remanded it for a Daubert hearing and a new trial. And our question was, well, if the court holds a Daubert hearing and says the evidence comes in, why do you need a new trial?
Exactly.
So hopefully the court will change that aspect of their ruling.
Wow. So it's one of the things I'm taking from what you just said is for all the lawyers listening, it's really good to know what's being argued in front of your Supreme Court and what applies to the type of law you're practicing it.
My partners and my associates make fun of me because I'm like a law nerd in that way, and I watch the cert petitions, and the court has a website where every day they post every reported and unreported opinion.
Yeah,
and I read them all.
I actually used to do the same thing. And one of the really good things about being an active member of your state trial lawyers association, and I know everybody at your firm is, especially since Alicia used to be president of your trial lawyers association, Alicia Hawk from your office, is they will let you know what's happening, when it's happening, especially if it has something to do with tort, professional liability, things of that nature.
That's right.
Now, how many times did you have to try the case that went up?
So I only had to try it once. One of the things that was frustrating, though, is we had our motion for summary judgment hearing, and the judge held the matter sub curia, and it was complicated, so I don't blame him for that. But he issued his ruling about 5 days before the trial was supposed to happen, when he took it away for us in summary judgment. And 2 of our experts in this case, one was flying in from Australia, and the other was flying in from Israel, 2 of our 5 or so experts. And so it was, we were gearing up, we were ready to go. Both sides had filed and prepared motions in limine and responses. It had been specially assigned to a judge and a different judge. And then we get by fax a ruling granting the motion for summary judgment. So that put everything on hold. And obviously we took the appeal up to the intermediate court and all the way up, and it came back, and we just tried it once, and the case is over. They paid the judgment in full.
Oh, that's great.
Yes.
That's always nice. That's always the question I like to ask people when they tell me about a $48 million verdict. I always want to know, well, how much did you get paid?
Well, and again, full disclosure, the jury came back with like a 1.8 something, but because Maryland has caps on non-economic damages, that amount was greatly reduced. It was in the, again, I forget the number, in the mid 500s somewhere. That it was the ultimate recovery in the case. But it was still a very gratifying and satisfying result, because they fought tooth and nail. I mean, there was a 0 offer from day one. And
that's incredible.
Every piece of evidence was fought, tooth and nail. It was a battle during trial. So
I'm cross-examining this expert, and he's not telling me that turning and repositioning is the cornerstone of pressure ulcer prevention, because there is no evidence-based medicine saying it works. And my next question to him, like your study, is, well, how would we get evidence-based medicine saying turning and repositioning works? Would we just tie people down and see if they get a wound, and then have somebody else turned and see how their wound progresses? And he said, well, that's how it would be done. And I said, and are you really telling the jury that because that hasn't been done, which would be unethical in every country except maybe one back in the 40s, and he caved after a while? And it sounds like your study, I mean, how could you possibly in that study do what they did and not think they're responsible?
Well, because their defense was every house in Baltimore City was a hellhole. So they were better off than they would have been had they not been in the study. And so the benefit of the study was being in the study. But
wow.
That was the defense. Now, the case, a lot of our cases, we didn't bring a separate informed consent claim to trial. We had filed one, but we let it slide.
Right.
But it was still, the informed consent that they gave was still relevant, because it was, what would a reasonable researcher do under the same or similar circumstances? It's a negligence case, but this, instead of against a doctor or a nursing home, it's against a researcher. So the standard is, what would a reasonable researcher do under the same or similar circumstances? And they had this informed consent, which would make you laugh out loud if I could show it to you right now. It was horrific. So that's what our experts hammered on at trial, the informed consent, not telling mom that the landlords and Kennedy were in cahoots, that the landlords were being paid for the repairs, that they could not they could not get the money if they didn't rent to a family that didn't have at least one child who qualified for the study. And really hammering home, and in my opinion, just making them look ridiculous about how they can justify deliberately putting kids in harm's way to compare their blood lead levels as against different levels of repair. It's literally using them as guinea pigs.
So you just said something that was pretty interesting, which is a really good segue into what we were going to, the second thing we wanted to talk about, and that is, when you're at trial, how are you proving your case, or more importantly, getting things into evidence? I assume you had to put that informed consent agreement into evidence so the jury could actually see it.
Correct.
Now, what I've learned in my 30 years, I'm much younger than you are. So what I've learned in my only 32 years of practicing law is a lot of people will read the book of evidence, but not really know what to do with it. Has that been your experience?
Yes. And I mean, and that, this sounds so cliche, but that only comes from doing it over and over and over again to get the feel, and because you can read all the rules of evidence, you can go all to the seminars you want, you can listen to experienced trial lawyers talk, but unless you're sitting at the trial table trying to get something in, and the other guy or the other attorney over there says objection, and the judge looks back at you and she says, counsel, so yeah, I mean, when you're preparing for trial, literally, when you're doing your exhibit list and getting things pre-marked, I mean, and of course, well before that stage, you should be thinking, how am I going to get this piece of paper into evidence every single time?
And I assume, because you guys have a lot of associates, and I'm sure you've trained a lot of lawyers over the years, you'd have to almost tell people to start doing that from day one of the case.
Yes.
How do you at your office go about thinking about that?
Well, so we have some great team leaders who run the different areas that we practice here, and I mean, they are really good at that. And they are really good at, when stuff comes in, it's very easy when you're hectic and going from day to day and trying to meet deadlines to say, oh, I got the doc production in from the defendants, and you scan it in and you forget about it until you have to prep for a deposition, right? Or you got your own records in and you scan it in and say, okay, if you can try to make it a habit of looking at everything, even cursorily at the beginning, just to see if something says to you, uh-oh, or, right. That's the way to do it, not to wait until your pretrial statement is due or something like that, because it might be too late.
One of the things we used to do, and it really helped, is in our list of things to do is prepare requests for admissions. Do you have requests for admissions down in Maryland?
They are a godsend. I mean, you can.
What do you mean?
So if obviously you're going to have some admissions that are standard from case to case.
Right.
But again, if you treat every case as its own entity and really sit down and just don't change the caption and mail them out, but really think about what am I looking for here? What are the facts of this case, and tailor your admissions. It can make your proof so much easier, and you might even get summary judgment if you're lucky, and for certain parts of your case.
One of the things we always did, even before I did nursing home work, even when it was back in the early days when it was auto, whenever we got a picture of property damage or a picture of an intersection, they immediately would go with a request for admission. Do you admit that this is the picture. This is the picture of your client's car. This is the way it looked on such and such a date. It shows the damage, things like that. Because then if they say no, and you have to go and prove it at trial, in theory, you're entitled to costs and fees. And I say in theory because you never get them. But
the defendants would.
Yeah. Oh, there's no question. But if you do that, it makes getting things into evidence that much easier, because if you have the request for admission, it's going to go in as a joint exhibit more often than not.
And in this case, though, with the documents, I mean, we had good, experienced lawyers on both sides of this case. And so there's only a few documents that we fought about. And so nobody was going to stand up at this trial and say, objection, Your Honor, authenticity. Okay. There was a few documents that we were fighting about, authenticity wise and admissibility wise, but not, is this what it purports to be kind of stuff.
One of the biggest things I've seen, both in trying cases as well as just watching, like in New Jersey, we had every other Friday were motion days, and you would sit and you'd be 30th in line and you just have to watch all these motions, is the concept that people would not be able to grasp of hearsay within hearsay. So they would be arguing, well, the document's authentic and it's a business record, therefore everything contained in it is the same.
Yeah.
It should be admissible. And let's talk about that a little bit.
Sure. So before we got started, we were just chatting about what we're going to talk about. And in a case, I would say a couple of years ago, there was a nurse's note from the medical record, which for sure was a business record. If it was her notes of what she observed, that document comes in every single time. But contained within that note was her note that said, Joe Blow told me that my patient said this, and wrote that down. She didn't hear the patient said that. She wrote down what Joe Blow told her the patient said, and the defendant was trying to get it in. And I said, Your Honor, yes, the four corners is a business record, but it's hearsay within hearsay. It loses its indicative of reliability because of that, and that part of the document should be redacted, and the judge kept it out. So you got to watch that.
Yeah, so that's something I think all lawyers should remember. It's not just the document, it's the words within the document. Right. And we had a trial once where it was claimed that our client was a fall in a nursing home out of a gurney. And the question was whether he fell or whether he got up to go to the bathroom and he was told not to, and ignored what he was told. And it was a rehab, so he was fine mentally. And in the ER records, there was something in there that said he got up and went to the bathroom. And we argued back and forth as to whether it should come in. I argued it shouldn't. They argued, well, it's a statement made for medical treatment, so it should come in. And the judge ruled, well, I want you to go take the deposition or bring in the person who wrote the note in order to get it in. And of course, the insurance of the nursing home did that. Well, the person really didn't know, but he said, if I wrote that, that must be what he said to me. And of course, that was the moment that we lost the trial, because we were hoping it would be kept out, but instead, not only did they let it in, but now they had the person who wrote the note testify, I never would have written that if he didn't say it. Now there's no argument anymore.
Procedure, all that stuff.
Yeah. So now you're done. But I think that's what I see a lot of times is people look at just the document and say, well, it's authentic. It's a government report. It's this, it's that. They have difficulty realizing that doesn't mean the facts within the report also come in. Do you see that as issues with younger lawyers?
I mean, that's one example of issues with younger lawyers. People think hearsay. If somebody comes in and says an out-of-court statement, then it doesn't come in automatically. But, and this is so simplistic, but for younger lawyers, it's not. If it's not being offered for the truth of the matter asserted, then it's not hearsay and it comes in. So, there's some knee-jerk reactions, and it's not just with the evidentiary rules. It's with, even corporate, when you're looking at corporations and in nursing home cases, the people behind the corporation, ABC Corporation owns this nursing home, but Mr. Megabucks behind the corporation, he can't be held personally liable because it's owned by a corporation. No, you got to look at the source of the duty. You got to look at the regs, the Watermelon Book, or whatever regulations apply, and say, who does this regulation impose a duty upon? And if it imposes a duty upon the person who is in charge, who is the man behind the curtain, so to speak, then that person is liable. It doesn't matter that ABC Corporation owns the nursing home.
Especially if you're going to show that person influenced the decisions. If it's under capitalization or something along those lines, you could really hold them in, not only piercing the corporate veil, but as directly negligent. There's some great case all over the country about that.
You just said the magic words that you don't have to do. And this is a trap that people fall into if there's an independent source of duty to the individual, which is you don't have to pierce the corporate veil.
Right.
If there's an individual duty that's prescribed by a statute, a regulation, or an ordinance, then that person is liable regardless of the existence of some, the corporation. No,
and normally piercing the corporate veil in the states I've practiced in can be very difficult. Whereas if you can show a duty and then just have direct negligence against that person. But one of the things I've often thought of, and we used to do this in our old firm, was have cheat sheets for people who are going to trial. Invariably we'd have the younger lawyers trying the smaller cases, and we would say, all right, think before you go to court, what are you going to try to show the jury? That's what we would start with. Forget getting into evidence. What are you going to try to show the jury? All right, you should have a cheat sheet for how you're going to do that. If it's something, an animation or something with an expert, when you start asking the questions of the expert, does this accurately reflect a herniated disc? Would this help you explain it to the jury? Is this outside the ken of the jury? And, do that, and then you can at least publish it to the jury. Whether you can get into evidence is another question. Yes. Is that the type of thing that you've done?
I mean, yeah, and absolutely. And it sort of parallels what we were talking about before with the evidence, but yes, as we're getting up to trial, a couple of months ahead of time, we got this trial date. Okay, exactly. And that's when we start meeting with our tech people, with PowerPoints and all that kind of stuff. How are we going to demonstrate? How are we going to show what our theme is? How are we going to tell the jury in an opening statement what they're going to see? Timelines are awesome when they're relevant to a case. When you can have a timeline that pulls out the document that is relevant to the events as they happen. Because, you're talking to a jury, and some jurors are great at listening to you, and some jurors are great at seeing stuff. And you gotta accommodate every form of learning that a juror might have, and having demonstrative aids, timelines, diagrams. We had a trial recently where we had animations that we're using to show the process of what was going on. It's really, really important to get things as simple and down to basics as you can.
I've probably conducted pre-COVID, in the last year before COVID, 100 focus groups. And I can count on one hand how many did not want a timeline. Jurors love timelines. They love to be able to see it. They love to be able to visualize it, not just hear it. And when you can show them and tell them at the same time, it gives it so much more authority. And secondly, it makes them remember it that much more. And I do like the timelines you're talking about. We used to have people prepare them for us, especially in a heavy document case. If you could have an admission to a hospital and you can hit that date and the key part pops out with the highlighted what the initial complaints were, it's really difficult for the defense to overcome that wasn't the case, right?
Right.
It really is. Right. Yeah. Now, whether you can use that in your opening, I think it depends state from state. I was just involved in a case in Ohio that we just got a verdict on Friday. And there, although some of the depositions were of parties, so they're clearly admissible, you could not use them in your opening statement. You couldn't show them.
So around here, it depends. It's literally judge to judge. And
wow.
some there's no rule of evidence that prohibits it. So, if one side or the other says, Your Honor, I don't want them showing anything that's not in evidence yet, the judge could say, well, nope, you're not showing anything. And some judges will say, if you show your opening to the other side ahead of time, and they can pick out a document for one reason or the other they think might not ever get shown to the jury, then I'm not always keen on showing my opening head.
Wasn't that the big problem? And we just discussed this. I just discussed this with a client of mine. Is they had a huge PowerPoint, and I said, well, find out what your judge wants. A lot of judges I tried cases in front of would say, well, show them what you intend to use so we can get that out of the way. And I would rather tell a story with no documents than show them the documents. Yeah. I mean, there is a way we can weave a story, I think, without being completely reliant on tech in an opening statement.
Yeah. But both of us did it way back in the day. Yeah. But it's much more effective if you can, as we said, to show the jury what you're talking about.
Oh yeah.
Because that way you haven't built trust yet with the jury in opening, and so you're telling them what they're going to see. But if you can show them what they're going to see, I mean, that builds trust when you show it to them later.
Yeah, definitely. And just getting back to some of these cheat sheets, we would go through the exhibits and we would tell our lawyers, and if I was the lead trial on it, I would tell the person who's second or third chairing, I didn't need necessarily the cheat sheet, but I want something for every document. If there's even a question that I could hand to the court that says, look, here is the evidence. Here's the rule of how this gets in. Here it is if there's going to be an objection, because I found that certain attorneys, defense lawyers have a habit of doing the same things over and over, of objecting, even though they know that can come in. I don't know why, just to ruffle our feathers, especially during opening statements. Right. So we would actually make sure that we even had a trial memo ready. It's really just putting a caption on it because it's the same trial memo, right. Whether it's an admission, whether it's like in our case, the cost reports in a nursing home, are they admissible or are they not admissible? We'd have that ready, and we make sure that we do a request for admission, and we make sure that we have the signed ones. So I think if you do the work in discovery, getting it into evidence is a lot easier.
No question. It's all about preparation.
Yeah.
When you go to trial, it's all about the trial. I won't say the easy part, but the trial is you're done, because it's all the work is done before you get there.
Right. The trial's the fun part.
That's right.
I mean, that's what I always used to say. The trial was the fun part. And a lot of people said they didn't like the prep. I actually liked the prep. Taking the deposition of a not that important person used to drive me crazy. And sitting through depositions where the defense was taking the deposition would drive me batty, because there would be, 70 questions that couldn't be more irrelevant.
Right. As
to where the daughter of someone whose grandmother died in a nursing home went to high school. There's just no reason. And I've always wondered why they feel compelled to ask a date of birth and a social security number in a deposition when they already have it in an interrogatory, and they know we're going to object and say we don't want it in the deposition for privacy purposes.
Right.
But such is life.
Because they ask it because it's on their outline that somebody else did. That's why.
That is true. But I think from both Brian and I, our tip to everyone is, if you're going to try to put something into evidence at trial, think about it during discovery. Either take the deposition to prove that it's authentic, get an affidavit showing it's authentic, or maybe do a request for admissions, then bring the court a cheat sheet. There's nothing wrong with a cheat sheet. We all used it. These are the 7 questions you have to ask to get a picture of the evidence.
Yes.
There's nothing wrong with that cheat sheet.
So there's a great book here in Maryland, and I'm sure they do it for state and federal. It's called Pattern Examinations of Witnesses. Now, obviously, it doesn't get into the facts of a case, but it literally gives you question by question by question how to get certain stuff in. I would highly recommend it to anybody.
And I'm sure that there's one for every state. Although I doubt the rules are that different from state to state on getting a document into evidence.
Yeah, it depends. But you're right. Yeah. Overall, it's the same.
And remember, Brian said it the best. When they object and say it's hearsay, the first thing you say, it's not being offered to prove the matter asserted. Then it's the next one is state of mind. And if you're desperate, maybe I'm showing my age, you say re geste. No, but it really can be, it's really truthful, Judge. But
There's
more
always
often,
that catch-all at the end,
yeah,
right? With all the exceptions, there's always that catch-all.
there's always the catch-all, but know it. And don't be looking the first time in front of the jury. That's going to piss them off. Know it. Even if you just take a copy of the rule of evidence and put it in front of you, at least it's in a manila folder, and you can say, Judge, here. The jury will appreciate that. So, well, thank you, Brian.
That's my pleasure.
It's been fun, as always. I always enjoy talking to Brian. And again, it's Brian Brown from Brown and Barron. I tease Leah all the time. I say, is it Brown and Barron or Barron and Brown? And she says something different than you, I think. They are excellent lawyers in the state of Maryland. And Brian, again, is the most recent recipient of the Trial Lawyer of the Year by the Maryland Association for Justice. Brian, thank you very much. I really appreciate it.
Thank you very much, too.
Again, this is Saul Gruber from Gruber Trial Consulting, your host of The Jury Thinks What, a podcast by trial lawyers for trial lawyers. And I want to thank Brian Brown, this week's guest. Brian, again, most recently was named the Maryland Association for Justice Trial Lawyer of the Year, and he had some excellent tips on using the rules of evidence at trial, especially for those who are younger lawyers. He talked about using cheat sheets. In other words, have a list of questions that need to be used to get different things into evidence, as well as do the correct discovery with requests for admissions to help that along. It may not be pretty, but as Keith Mitnick says in his book and podcast, you're not being paid to be pretty, you're paid to be persuasive and to be right. And having a cheat sheet will help. Again, thank you, Brian. We now come to the part of the podcast where we have a little nursing home tip for those of you engaged in nursing home litigation. We've all been down the road where we attempt to get the nursing home records in pre-suit, but we never do. They don't come. We're ignored. The nursing home is hoping will just go away. There are a number of ways you can go about getting the records, with the first one being reporting them to the ombudsman for your state. There's both a federal and state regulation saying that the resident or their agent is entitled to the medical records. And there's nothing worse for an administrator than a call by the ombudsman's office. If that doesn't work, or if the ombudsman chooses not to get involved, depending on what state you're in, you can file a pre-suit application requesting the records or an order to show cause. What we know is you'll win both, and you will receive a court order, which makes it even better when the records are amended during litigation, and you can ask the administrator, how many times have you received a court order mandating you giving us records? It becomes a little bit persuasive, and you get under the skin of the nursing home lawyer as well. So try those things. I think you'll find that you'll get the records that you need. Whenever we are trying cases, we are trying to get the jury to understand they are the most important people in the room. It's certainly not you. You can argue whether it's the judge or not, but you want the jury to know that their responsibility is sacrosanct. Their responsibility is incredibly important. I ran across this quote from Sylvia Earle, an oceanographer. And she says, many of us ask, what can I, as one person, do? But history shows us that everything good and bad starts because somebody does something or does not do something. And this is the chance for you to show that to the jury and say, you have this opportunity right now to do something for the plaintiff, to make it right, to tell the defendant you must reimburse for what you have taken from the plaintiff. And that's a good segue to doing that for the jury. Again, this is Saul Gruber from Gruber Trial Consulting, and thank you for tuning in. See you next time.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.